A very warm welcome to all of you joining us today. First of all, a very happy Independence Day to each one of you. Independence Day marks a special day to us. Being was founded 7 years ago on this day. I am genuinely glad you have chosen to spend a part of our evening celebrating it with us. BEAM, the Bureau for Empowerment of Arbitration and Mediation, is a charitable trust started by a group of like-minded area professionals with the common vision of affordable dispute resolution and awareness creation. What makes us little different is where we work. Most of the arbitration in our country happens in metropolitan cities like Mumbai, Delhi, Chennai, Bangalore, etc. We deliberately choose to work in a second tier cities because the heart of the MSME business happens in a second tier cities, such as our own Coimbatore. Think about who is really MSME is. A small contractor who has finished the work, submitted all the bills, and now is waiting for his own payment for 6 months, 1 year, sometimes even for 2 years. For money which is rightfully belongs to him. He also has wages to pay. He also has EMIs to pay. In India, 60% of the exports business are run by MSME businesses. So that needs a great support, especially with the affordable payment recovery mechanism from the buyers. BEAM also focuses on knowledge sharing to government law colleges, where we help law colleges and other students to gain a current international developments and career opportunities. We also assist in young professionals to gain internship in ADR practices. Today's session opens up affordable dispute resolution option to MSME business in the second tier cities. I must thank our keynote speakers for today, two eminent arbitrators in our country, Mr. Inbavijayan sir and Dr. Pradeep Reddy Sarvareddy, who has very wide experience globally. They have immediately accepted our request to speak in this regard and share their wisdom. Definitely, it adds a value to our business strategy. My sincere thanks also to Builders Association of India, who are the patrons to this event. Today's session is being organized by a very young team, including myself. We request you to support the young team's effort in organizing such sessions. Today's session is mainly guided by our managing trustees, Madhumitra, Kartikeyan, and other instrumental professionals who is instrumental in founding this mission along with several area professionals. My sincere thanks to them. One small request to participants: if they have any technical issues, kindly let us know either by chat or a WhatsApp message in a group. We will ensure the smooth resolution. I also kindly request all of you to mute your mic until the speaker turns over. We will surely help to address the queries towards the end of the session. You may kindly share your questions in WhatsApp or by raising your hands. We will unmute your mic. Once again, thank you for being here. Let's begin.
Good evening, all. Without further ado, I would now like to introduce our first speaker of the day, Professor Veeraraghavan Inbavijayan. He is a distinguished international arbitrator and an area specialist with over 2 decades of dedicated arbitration practice. LLB graduate of Dr. Ambedkar Government Law College, University of Madras. He began his career in litigation before the High Court of Madras and has since focused exclusively on alternate dispute resolution since 2001. He expertised as a sole arbitrator and also acted as a counsel in over 450 domestic arbitrations and 19 international arbitration matters, spanning commercial, maritime, construction, finance and banking, IPR, and international trade disputes. He is accredited by leading global arbitral institutions, including Hong Kong International Arbitration Center, SIAC, DIAC, ICC, ICA, CIETAC, etc., and also holds registrations as a foreign lawyer with Singapore, the UK, and Kazakhstan. Currently managing partner at KOVE Global LLP, Professor Inbavijayan also serves as the chairman of the SICC Arbitration Committee of India branch. He is also Global Advisory Board member at Hyderabad Arbitration Center and founder of the Global South ADR Alliance. His professional standing has been consistently recognized in the Chambers Asia Directory since 2010 and the International Who's Who of Commercial Arbitrations 2008. Over to you, sir.
Good evening. First of all, congrats and best wishes for being taking its 8th year of starting. Anyway, 7 years have gone. Interestingly, the beam, as rightly mentioned by Mr. Jay, Ms. Madhumitra, as well as the team members, under the guidance of Mr. Ramasubramaniam and all other who are the stakeholders, the promoters, the well-wishers, and obviously the beneficiaries and the mentees of BEAM on this special occasion along with our Independence Day. The topic given to me along with my colleague Dr. Pradeep Reddy, it is very interesting and most significant whether the organizers were aware or not. Hardly 4 days back, the MSME Act 2006 had an amendment on 11th August 2026, wherein there is significant reforms by way of amendments to this act has been brought in and rightly focusing on the construction disputes. Hats off for BEAMS for choosing this topic, and hopefully for another 30 minutes, I'll try to just cover whatever I have just planned to share with all of you, and special focus on the existing legislation, that is MSME Act 2006, and the newly passed amendment 2026. Here, it is also a very significant point for us to take into consideration this particular development, all because of the word arbitration. Arbitration being a very prominent mechanism of resolving disputes. Certain developments and the difficulties what the MSME has faced, particularly being the other party, the state enterprises or the public sector undertakings, and most of the time the state governments, and significantly on the term work contracts. There are a lot of challenges in this sector. My presentation, it's all guided perfectly by Claude. The Claude has given me 15 heads, and the 15 heads are significantly going to cover upon the construction part, the MSME sectors, the difficulties, the challenges, and obviously the dispute resolution along with the amendments. As rightly mentioned by Mr. Jainivas, when it comes to India's economy, MSMEs
Sorry, sir, your mic is off.
Yes, now I am audible?
Yes, sir, very much.
Fine. when it comes to MSME, particularly on the sectors, this unique sector of an economy has a great share in the GDP to the extent of around 31%. It also has a significant part in the exports, almost 50%. And to some extent, a reasonable contributor for the manufacturing output amounting to around 35%. And taking into consideration the population, more than 40 crore people are employed across the MSME sectors. This is quite significant statistics, what we can look into when it comes to MSMEs and their contribution to the economy. Significantly, MSME Development Act, which was notified in the year 2006. Earlier, there was a practice of small sector, middle sector, and the large sector, the private and the public sectors. The terminologies have just gone into a new structure called MSMEs. And the Development Act was notified in 2006 significantly to scale up their contribution to the economy and taking into consideration the diversity, what it all involves, and to the extent coping up with the digital development. The crisis or the challenge, what the MSME were facing or even now facing or in future also they are going to face, is all about delayed payments. And it has to be a common issues significantly when these MSMEs are going to deal with large buyers. Taking into consideration the construction sector, MSMEs also have some challenges. It might be based on projects. It might be on elongation of the contract periods. Most of the time, the contribution given by MSME has become a challenge, an impediment which has to be effectively addressed. In this aspect, this MSME Act 2006 significantly deal about delayed payments. When you have a quick look on section 16, 18, 19, 24, predominantly in relevance to the delayed payments, whether it is on the interest part, whether it is on the facilitation council, or whether it is on the pre-deposits when you're going to challenge an award is against either of the parties. This particular law has a unique role. Having said that, for 5 to 10 minutes, I want to just, instead of sharing, I want to just put out some significant aspects on the MSME, the original or the Principal Act of 2006, and the stance on the arbitration. As repeatedly highlighting, MSME sector faces commercial disputes. While arbitration going to offer a fast alternative, this MSME Development Act 2006 mandates institutional arbitration and not ad hoc for such disputes. And when we just analyze why it was not recommending ad hoc arbitration, it was felt that the ad hoc arbitration's lack of support, procedural uncertainty, having high or significant risk for MSME sectors, it is better to avoid ad hoc. But in contrast, institutional arbitration provides well-structured rules, administrative support, qualified arbitrators, as well as, to some extent, predictable process, which is crucial for the resource-constrained MSMEs. No doubt, this legal imperative consistently it has been upheld by Indian courts, ensuring efficiency, fairness, level playing field, preventing delays, as well as protecting the vulnerable MSMEs so that they can quite focus on their vital business or economic contribution. Looking into the core element of why MSME Development Act was not or wanted to be shy away from ad hoc arbitrations, it is basically an arbitration which is do it yourself. This do it yourself model, where parties themselves manage each and every aspect of the dispute resolution process, setting from the rules or mostly depending upon the existing Arbitration Conciliation Act 1996, along with selecting arbitrators, organizing the hearings, acting as depositories. Everything is on its own. There is no a supporting mechanism. It is quite flexible, safeguarding party autonomy, cost effectiveness, confidentialities. All these are there. These advantages are quite superficial for MSMEs also. But the pitfall, which is the lack of administrative support, puts the entire burden starting from scheduling, communication, the document exchange, the hearing venue arrangements, as well as the financial managements, entirely falls on the disputing parties, the supplier and the purchaser. Looking into MSMEs, they're mid-size and small enterprises typically lack dedicated like a legal department or even an administrative resources to handle quite of these complex tasks in an effective and efficient manner. And to add on, without having a pre-established rules, the aspect of timelines, discovery, evidence admissibility, all might be attracted under the procedural wrangling dealing to delay in the proceedings. It might start from even agreeing for an arbitrator or even seeking the arbitral appointment in the high courts. Too much of court intervention. Anyway, it's facilitation, but it might take some additional time so that we have to rely much on external agencies, particularly the courts, to facilitate that process in an effective manner. Crucially, ad hoc settings can create some power imbalances. Sometimes even the larger players, being one of the parties, they might have quite a phenomenal resources, might exploit this procedural ambiguity, and being as MSMEs administrative limitations create a uneven playing field. On the other hand, when we look into institutional arbitration, no doubt these MSME Facilitation Council also prefer to take it to the institutional arbitration. In India, we do have specialized institutions or even general institutions which can effectively administer the entire process. They have comprehensive rules, predetermined provisions, transparent frameworks, as well as dedicated administrative support. This comprehensive administrative support might be, it's not that I'm just advocating institutional arbitration alone, but most of the time, it gives a significant benefit for MSMEs. The MSMEs are freed from these administrative burdens. Let them concentrate on their core business and significantly their legal positions or their legal submissions. On the other hand, institutions would promote cooperation between these parties, facilitate effective proceedings, administer that particular proceedings with a reasonable administrative fee. It can be also streamlined processes like Singapore. When you look on Singapore institution, particularly SIAC, has streamlined procedures. They have streamlined procedures, expedite procedures, and normal procedures. These streamlined procedures are very, very conducive, wherein even within 90 days, an arbitration can be completed. That's what now this, when you look into the 2026 amendment, you can find arbitration is possible to be concluded within 90 days, depending upon certain preconditions, even for MSMEs. But institution, they do have such streamlined processes, and there might be a possibility to lead more predictable and contain a legal cost, a limited cost, or a predetermined legal cost. When you look on this Micro, Small and Medium Enterprises Development Act 2006, particularly through Section 18, which leaves no room from ambiguity regarding the type of arbitration which is permitted for disputes referred by the Micro and Small Enterprises Facilitation Council, MSEFC. It states that if conciliation fails, that is, a conciliation happening before the council may either itself act as arbitrator or refer the matter to any institution or center providing alternative dispute resolution services. Here, this MSEFC, that's a Facilitation Council, either conduct the arbitration directly or refer the dispute to a recognized institution. This option of referring the dispute to independent sole arbitrator appointed by the parties themselves operates outside of an established institutional framework is not permitted. Either the Facilitation Council act as arbitrator or it will be referred to recognized institutions. We do have many judgments wherein a referral to a sole arbitrator appointed by the parties, even if it is aligns with the prior contractual agreement, it is deemed to be contrary to the letter and spirit of this act, MSME Development Act. It is quite interesting to look upon these provisions. 18 is significant when it comes to these facilitation councils' role. But 19 also, which speaks about pre-deposit requirements for challenging awards, that is, to the extent of 75% of the award amount, then only challenge can be entertained in the course. These were very, very prominent provisions which were effectively facilitating in the initial period of the creation of this legislation. But we need to have some changes. 20 years have gone. There are a lot of developments and reforms were expected in various aspects like classification, whether it is an investing or the turnover-based classification or memorandum filing, which is free or voluntary. When it comes to dispute resolution, certain time frames. When it comes to enforcement, now instead of conciliation, mediation is suggested. An arbitral award can have a security like a land revenue. I'll try to explain in another 5 minutes. There is expectation of digital infrastructures. We wanted to go from physical dispute resolution to online dispute resolution with certain payment mechanisms also, wherein the invoices can be generated under TREDS. The Facilitation Council's expansions. Earlier it was very restricted, 1 or 2. Now it can be established in many numbers. And just now I mentioned about the payment mechanisms that TREDS has now become mandatory subject to this amendment. And the worst part is the decriminalization. Warnings and penalties are going to replace penal provisions in these specified cases. Now, looking into this particular amendment, what has been brought in, the very objective of this amendment states that it is going to seek reduce payment-related constraints, make dispute resolution more time-bound, and the compliance to be simple. And in a macro level understanding, the lawmakers, while bringing these reforms, they wanted to facilitate the actual growth, development, and competitiveness of MSMEs while promoting ease of doing business. The key areas which we earlier saw significantly brings out a new era for MSMEs. When you take on example of classification, originally in the Principal Act, MSMEs were classified on the basis of prescribed investment thresholds for, you can say, plant and machinery in manufacturing, equipment in services. But now, this amendment is going to take this classification on the basis of investment in plant and machinery or equipments, as well as turnover. quite a reasonable, fair amendment. And looking into these registration, MSME registrations, the enterprises engaged in manufacturing were required to file memorandum with specified authorities, and filing of memorandum was voluntary for the other MSMEs. Manufacturing were expected to comply with certain conditions. Now, it is totally voluntary. This amendment makes filing of memorandum free and voluntary for all MSMEs. We are expecting out of this amendment for the central government to notify a national platform for this purpose, and the state government also may come out with some state digital platforms. And ultimately, what we can see is that this registration would make the state schemes benefits reaching or extended to the MSMEs registered on both national and state level platforms. Now, other aspects like payments through Trade Receivables Discounting System, TREDS, Trade Receivables Discounting System. This is a new introduction, an addition in this amendment. In the Principal Act, we didn't have. According to this, all central public sector enterprises are required to settle invoices for goods and services procured from the MSMEs through this platform. Here, it addresses effectively the payment-related issues. The states might mandate their public sector enterprises, authorities, or entities also to use this for invoice settlement. It is really transparent. Coming to the significant part of the amendment, MSEFC, that is a Facilitation Council, the Principal Act permitted the state governments to have one or more MSME Facilitation Council. They have used the word one or more. But now this amendment permits state governments to establish multiple micro and small enterprise facilitation council. This is a good beginning wherein they are going to establish, and there is possibility for faster resolution of payment related disputes. And not only that, they are going to be empowered to provide adequate infrastructure, resources, physical infrastructure, digital systems, trained manpower, whatever necessary is all going to be done for that Facilitation Council, not one or few. It is going to be multiple MSEFCs. In the mediation and arbitration front, earlier we did have, that is, the Principal Act was mentioning about the mediation, as well as if the mediation is not successful, the dispute may be referred for arbitration. They have used the word may be referred. Now, in the amendment, central government may establish an online mechanism for conducting online mediation or arbitration. And not only that, certain time frames similar to 29 capital A of Arbitration Constitution Act 1996, timelines have been introduced for mediation and arbitration. Very interesting. Specific timelines like, first, the MSEFC, Facilitation Council, or the Mediation Service Provider, MSPs, under the Mediation Act 2023, must complete mediation within 90 days from the date fixed for the first appearance. 90 days is given. That is 3 months. Next, if the mediation is terminated the facilitation councils are required to refer the matter for arbitration within 30 days. First 90 days, then there is a time given 30 days, assuming that it is going to be 120 days, 4 months. Further, this facilitation council or an institution or a center providing alternative dispute resolution services has to make or must make the arbitral award within 90 days from the completion of pleadings. It's a very concise timeline similar to streamlined procedures of the Singapore International Arbitration Center model. And going along, two other points. Regarding dispute resolution beyond this award, when there is going to be a challenge or setting aside process in the court, 75% of the award amount was expected to be deposited. Now, this bill also allows such application. While the application is pending, the court may direct a reasonable portion of the deposited amount, which is already paid, that is 75%, to be released to that MSME supplier, the victim. The courts shall direct payment to MSC, that is a micro and small enterprise suppliers, when an application to set aside is pending for more than 6 months. And interestingly, the law also is suggesting that minimum 50% of that awarded amount has to be released. And the final point, what I wanted to insist for the construction sector, particularly within this MSME, when it comes to recovery of dues, there is a new inclusion in this amendment. The mediated settlement agreement, if the mediation was successful and MSA would be signed, or if it is by way of an arbitral award, either way, it can be recovered as arrears of land revenue. That means this applies to agreements or awards made under Section 18 by the Facilitation Council or a mediation service provider or an ADR institution. Recovery may be undertaken through district collector, there's a district magistrate or subdivisional magistrate, or any other notified authority. Here, this notified authority should have a jurisdiction over the location of the buyer's assets. All these significant amendment proposed in this Amendment Act 2026 gives a greatest opportunity for all the micro and small enterprises to be really successful. And interestingly, whatever the cases, I have just prepared some cases, whatever, whether it's the Delhi High Court or the Telangana High Court, anyway, Dr. Pradeep Reddy would deal on those case laws, or whether to address on the work contract debate or the overriding effect over the Arbitration Conciliation Act 1996 being this MSME Development Act of 2006 being a special law. Most of the time, it has been considered that this is overriding, being a special statute, it will override the Arbitration Conciliation Act 1996. Now, with all these interpretations, we have got a great timeline according to this amendment 2026. 90 days for mediation, 30 days for the referral after the mediation ends, then 90 days for arbitral award after completion of pleadings. Completion of pleadings, if you look on the Arbitration Conciliation Act, has 6 months. We have to wait and see whether that 6 months would be taken into consideration or there will be a unique rules to be established for this purpose. But considering Arbitration Conciliation Act, the time bound of 12 months, for completion of pleadings of standard arbitral award, MSME timeline is quite short, that is 90 days from the completion of pleadings. A final word as a takeaway to all of us is the development of ODR, digital dispute resolution, particularly online dispute resolution. Now, MSMEs can file complaints digitally against buyers. Hearings can be conducted digitally. It also going to aim timely and cost-effective dispute resolution. No doubt, Udyam registration, or you call Udan registration, TREDS, Samadhan, and the nationwide network of the facilitation councils is going to have a great impact along with this ODR on construction arbitration, wherein we can expect reduced geographical barriers for project based on MSMEs, faster initiation of proceedings, and it is going to be having a great transparent and tracking of the entire process. Hope these are some points what I wanted to share about the construction industry being part of the MSME and the arbitration or the dispute resolution. Thanks for MSME topic taken by being on its 7th birthday, and we are very happy that it has coincidentally followed this amendment which happened hardly 4 days back. Thank you.
Thank you so much, sir. We truly appreciate your comprehensive breakdown of this topic. Now, moving ahead with the session, I'd now invite Dr. Pradeep Reddy to take the session forward. Dr. Reddy has a dual qualification as an engineer and as a lawyer. He has completed BE in Civil Engineering, LLB Honors, Master's degree, and a PhD from USA. He has also completed a certificate course on contracts from the Harvard University. Sir has numerous certifications to his credit and is also empaneled with various area institutions. Sir has more than 25 years of professional experience. He has worked extensively in the field of infrastructure involving contracts, their legal issues, and ADR methods. He is also experienced with disputes related to company law, financial institutions, information technology, and digital laws. He has worked on projects for several external funding agencies, multiple government organizations, several multinational companies, etc. He has also numerous publications in prestigious national and international journals. He is also a guest faculty for Manipal Law University and has taught the subject on arbitration law for LLM students and professionals. He is involved in numerous cases as an arbitrator and also as a counsel in arbitration. He is currently practicing in the Supreme Court of India, different high courts, and the other judicial forums throughout the country. Sir, we look forward to your insights now.
Thank you. Once again, I have to repeat Mr. Inba's views that obviously congratulations to being first. That is something which we cannot miss out today. And happy Independence Day to you all. One thing, Mr. Inba, I have to say that you are very optimistic about the process, but we need to have faith, and I agree with you on that part. But one of the things that I learned from somebody, a senior, on how to keep a presentation or something like this interesting is to differ with the others' views. I have a presentation to share with you which may agree with most of the things which Mr. Inba has said, but I'll purposefully choose the other way and say something that is different for my PPT so that it'll become interesting. But broadly, yes, I agree with Mr. Inba. So let me start my presentation and then we'll see how it has moved on. Okay, I hope my screen is visible.
Yes, sir.
Yes, sir.
Okay, thank you. So I have a standard disclaimer as always, and I suggest you all to do this in everything that you do. So I'm not responsible, or nobody is responsible for any mistakes or anything that I say which is not correct as on date. The reason being, this particular slide is the most important slide in all my presentations. Reason is that you should not believe anybody. And when I mean anybody, no exceptions, don't even believe me. Verify for yourself. So whatever you think you know may not be up to date. And literally, the law is dynamic, and that's why we are talking about the new amendment which came about 2 or 3 days ago. And remember, sometimes we are talking about rules, sometimes we are talking about exceptions. So what you could be asking me could be an exception. And so if I say 2 plus 2 is 4, that is the rule. But the exception could be that 2 plus 2 could be anything that you want. So as an advocate, keep your mind open because every case is unique. Now, what is this MSMED Act? Well, it is still a baby. It's completed 20 years, but it is still yet to fully evolve. There are many contradicting judgments, and certain important facts or legal aspects have been referred to larger benches which have not yet been constituted, and there are pending issues. So if you ask me what is this specifically in black and white, I cannot answer you. So my recommendation would be better safe than sorry. That means that try to adopt the least controversial path. That way you could save time in court. Now we are talking about micros, small and medium enterprises facilitation council. But why are we talking about court? Well, that is the nature of pretty much every dispute in India. You could be saying you are not disputing, you're only asking for delayed payments. Well, that is a dispute. Now, going forward, MSME is online. It has been online for some time, and it's going to be fully online everywhere throughout the country. About the time that COVID kicked in, the central government has actually removed the statutory thresholds and modified the classification of MSME. So these are the limits that you can see on the screen. So any enterprise which has an investment limit up to 2.5 crores or annual turnover up to 10 crores is a micro enterprise. Similarly, there are certain criteria for the small and medium enterprises. And these can be changed by the government, not necessarily through an act, but just by a notification. So what is the purpose of this act? For the purpose that we are talking about, not for applying loans or for something else, but for the purpose of dispute resolution. Well, it is applicable for services and manufacturing sectors, but not for construction works. I'm not saying construction industry. Please understand there is a difference. In construction industry, you could be supplying goods, and that is covered under MSMED Act. You could be providing services as a consultant, and that is covered under the MSMED Act. But if you are doing a composite work, construction work, which includes both supply and construction, that is not covered under this dispute resolution provisions. And by the way, the MSEFC, that is a Micro Small Enterprise Facilitation Council, if you observe closely, does not have the letter M, the second M, which means that dispute resolution is not applicable for medium enterprises. So only micro and small enterprises can choose this MSMED Act for their arbitration or conciliation. So before the 2026 amendment, which is what I'm going to first talk about, is that within 15 days from the time that your goods or services have been accepted by the supplier, that is once you have delivered, then that becomes the time period. So how do you know that you have delivered? What is the evidence? What is the proof? That is the first question anybody is going to ask you. For that, maintain some kind of paper record. Say that I have delivered the goods to you on 1st August. Write so and so letter. So once that 15 days time period is completed and there has no written objections from the buyer, we are not using the terms contractor or supplier here. We are using two things, just buyer and supplier. Supplier as in like you could be the consultant, you could be the service provider, you could be the one who is selling the goods. And the buyer could be the government department, it could be another large company that is buying from you. So within 15 days, if you don't receive any written communication, it is deemed that your goods or services have been accepted, which means you are eligible for payment within a period of 45 days. And as I said earlier, only for micro or small enterprises. Now, what if your contract says that you will be paid within 90 days? It doesn't matter. Your statute, that is this law, this act, overrules your contract and you are entitled to payments within 45 days. So there are certain provisions in law which you cannot overrule through contracts, and this is one such a provision. And if the buyer does not make payment to you within 45 days, you keep getting monthly compounded interest, not simple interest, compound interest with monthly frequency. That is what we call monthly rest. And there are different interest rates. So the interest rate that is applicable for you is the bank rate notified as per the Reserve Bank of India. So it is not your fixed deposit rate or some lending rate as per the banks or something that which you have borrowed, but the rate that Reserve Bank has notified, which is known specifically as the bank rate. Now, bank rate is very small. You could be saying, how am I okay with 5% or 6%? And that is why the Act says 3 times of that bank rate. Current rate, in fact, this is a calculation which I updated today, is effective from 5th December 2025. The rate has not been changed. The current bank rate is 5.5% as per RBI. So 3 times of that comes to 16.5%, compounded with monthly rest. So it's 17.806% annually. That is on interest of 1 lakh. In 1 year, you will get an additional interest of rupees 17,806. In other words, in 4 years, 3 months, your money will double. And in another 4 years, 3 months, that money will double. So it is not bad if you keep on litigating for the next 5 years or 10 years, because every roughly 4 to 4.5 years, your money will keep on doubling. So 1 lakh today will become 2 lakhs after 4 years, and that will become 4 lakhs after 8 years. So it will be foolishness for the buyer to unnecessarily drag you into this dispute. Now, this is all something which Mr. Inba has already explained, that once you have a dispute, you need to reach out to the council. And the council conducts conciliation. Again, we are talking about the pre-2026 amendment. And if the conciliation fails, then arbitration is what is the next step. And its vague reference says within 90 days from making of such reference. Is 90 days mandatory? What happens if you take longer than 90 days? You being here the MSCFC, the Facilitation Council. And what is this 90 days? Does it include conciliation and arbitration? Well, these are several doubts which we don't have a clarity. And this is one of the larger questions that was referred to the Supreme Court. But anyway, the new amendment addresses this to a certain extent. Once you have an award in your hand, it is equivalent to a court decree unless it is challenged. But to challenge, the buyer has to deposit 75%. Now, why does it say, if you look closely, I believe a lot of your students, it says, unless the appellant, not being a supplier, has deposited 75% in the court. See, you are the one that is going to arbitration, or to be more precise, the Facilitation Council, saying that your payment has been delayed. Once your payment is delayed and you win that case and you are, let's say, entitled to 1 lakh, just taking my old example, with interest, then how can the appellant, not being a supplier, come into play here? That is because once you enter conciliation or arbitration, the buyer can also bring in his counterclaims. I'll repeat, it is not a one-sided war. It becomes two sides. Both the parties can have claims and counterclaims once you enter arbitration, which is why many people are scared to enter into arbitration, because the other side can just blatantly raise a 500 crore claim against you. And even if 1 crore is upheld, you will be the one that will end up paying 1 crore. So ensure that you have sufficient evidence before you proceed forward with any of your cases. Now, there are some more sections which talks about interest cannot be deducted from income and all that, which is about more taxation and penalties. So I'm not going to touch about that here, but there is that information. Now, this is the 2026 amendment. It was introduced in Rajya Sabha on 28th July of this year, just last month, and passed by Rajya Sabha within 5 days or 6 days, passed by Lok Sabha within 4 days. Presidential assent was granted, and the Gazette publication happened on 13th August 2026, just 2 days ago. But be very careful. The law is not yet in force. If you read the Gazette, it clearly says the commencement date for these provisions are as and when the central government will notify, and that can be different date for different provisions. So as on date, the 2026 amendment has not kicked in. It is there, ready, fully dressed up, but it's not yet in force. But let us still see what is happening. As Mr. Inba already said, we are now talking about mediation, not conciliation. But the Mediation Act itself has not been fully enacted, or it's not yet fully in force. So it looks like until the Mediation Act kicks in, this MSMED Act 2026 amendment for the section 1318 subsection 3A may not click in. But anyways, once that happens, council must act within 30 days from the termination of mediation. And then arbitral award within 90 days thereafter from completion of pleadings, but not from the reference date. Now here, I would like to differ slightly with Mr. Inba, because he really actually touched upon the specific aspect of pleadings and said section 23 subsection 4 of the Arbitration Conciliation Act, not the MSMED Act, Arbitration Conciliation Act, says that the time period is 6 months for completion of the pleadings, but there could be special rules or regulations for MSMED. Well, as of now, such rules don't exist. And until that rules kicks in, we are bound by the Arbitration Conciliation Act, which means that we have to wait for the completion of pleadings. So is completion of pleadings strictly 6 months? Not necessarily. As per Calcutta High Court judgment, which came out in 2025, I believe, and then followed by Allahabad High Court, they said 6 months is not mandatory. It is only directive, which means that your pleadings themselves could be dragged on for 1 year or 2 years. And your so-called 90 days time period for getting paid is not anymore. It doesn't exist anymore. At least on this screen, I see 90 days. That's 3 months. Plus 30 days. That's another 30 days. That's 4 months. Plus 3 months. That's 7 months. Plus 6 months for the pleadings. That's 13 months. If we go theoretically. And then you add to it any delays, you could be looking at least 2 years before you could get through this one. Now the jurisdiction, it has been much more clear now, says specifically that it is at the supplier's official address. So it is at your residence, wherever your office is registered. That is much more clearer. In fact, courts have already clarified that, but even otherwise, it's now more specific. And if I have to challenge, if I am opposing you and I have to challenge your award, I have to come to your location, your jurisdiction to challenge that award. In fact, some of these things were already clarified by courts, but now the statute has been amended to that extent. But remember, it's not in force. Now, amount recovery mechanisms is as per the earlier act, which stays still the same. You can recover under section 36 of the Arbitration Act, which is you go through the court as if it is a civil decree as per CPC, and you file an execution petition. And that's when all the real trouble starts. But that part aside, now we have two more provisions. One is through a deputy collector, which Mr. Inba has said, and that is not new. That is already existing as per our Revenue Acts. And the new factor which we can really now benefit out of is that it can even be considered as enforceable debt under insolvency and bankruptcy code. And this is something which companies, private limited companies, are really scared of. So if you can file a IBC, so which means once you're done with your MSE, you now have to fight a second battle in the IBC. But at least this is a good benefit in my opinion. There's also another added advantage is that the amendment now paves way for a mandatory release of 50% after 6 months after the challenge has been pending. Earlier, it was only discretion of the court to release 50% of the deposited amount. There's no hard and fast rule. You have to deposit 75%, and I could just say keep it with the court. But now half of that, which means 37.5% of your arbitral award shall be released to you. So this is a mandatory provision. There are penalties if the company is not filing its returns properly related to MSME, and even when they don't disclose these things in their tax returns. So there are severe penalties and they keep continuing further. This is important. This is only one slide, but you need to understand the interplay between MSMED Act and Arbitration Act. See, MSMED Act has only a few provisions which are unique for it. For everything else, you have to go only by the Arbitration Conciliation Act 1996. Now, as per the Arbitration Conciliation Act, you require a written arbitration provision to invoke arbitration. But under MSMED Act, you don't need that. It is a statutory arbitration which is conducted by the MSCFC or an institute referred by the MSCFC. The jurisdiction or seat has to be written in your contract as per the Arbitration Act. Otherwise, it will be reviewed by the courts under different criteria. But that doesn't exist anymore because the seat is as per your office location, which is very convenient for you. The time period as per the unamended act was 90 days. 90 days from when? I'm not sure. 90 days up to, if not what? Even the Supreme Court has still referred and not yet answered to that. But at least if you look at the amended act, still the time period is different from the Arbitration Conciliation Act. Interest rate obviously is much higher in the MSMED Act. And the mandatory 75% deposit is also unique. So except for these 5 aspects, in all other regards, MSMED Act relies on the Arbitration Conciliation Act. So if you don't know the Arbitration Conciliation Act, you will be having a difficult time trying to navigate through the MSMED Act. And this is where a lot of issues keep coming up. So let us look at the Arbitration Conciliation Act. I don't want to go through everything in detail, but the very first one, that is section 2, subsection 9 says that claim shall also include counterclaim. And this is what I said earlier. Once you invoke arbitration, once you step into MSCFC, I can bring in my counterclaims. See, I am the buyer and I cannot invoke MSCFC because you are the supplier. Only you can invoke MSCFC. But once you go there and you open the door for arbitration, I can bring in my counterclaims. Now, Arbitration Act says that the number of arbitrators has to be an odd number. But since it is statute, maybe this is not so strict as of now. But again, as I said, MSMED Act is still evolving. So it's not sure what is happening there. Now, grounds for challenge still the same. They have to provide their disclosure in writing. And section 30 talks about a settlement award, which can also happen even in MSMED. And the time period for setting aside the award is 3 months plus 30 days for challenging. If not, the time period is gone. You cannot challenge. And that is very strict. So, which means that if somebody does not challenge your award within 3 months plus 30 days, then it's gone. Now, what are section 75 and section 81, which I mentioned here as grounds for challenging? And this is a bone of contention every time with MSCFC. Section 75 is about confidentiality. What it means is that whatever happens in conciliation stays in conciliation. It should not be transferred to arbitration. And Section 81 also similarly, that whatever has been discussed in another forum like conciliation cannot be brought into arbitration. So if conciliation is separate and arbitration is separate and they are supposed to be confidential, how can the same people who are sitting as the MSEFC council members, how can the same persons conduct conciliation and arbitration? And this question has been referred to the larger bench of the Supreme Court. So until that answer is there, right now we are facing problems in courts. Anytime somebody wins a MSCFC award, the first thing we challenge is this. The same people have been sitting as conciliators and arbitrators. So how many conciliators can there be? Well, there can be an even number also, but it doesn't matter because again we are talking about the future, which is mediation. Now court intervention is, this is the challenge to the award. It has to be within, as I said, 3 months plus 30 days, and you need to mandatorily allow 75%. And the earlier provision said may allow seller to withdraw, but the new amendment says after 6 months you are entitled to withdraw half of that, which means 37.5%. And then you have to challenge under section 37, and then you have to face the SLP in the Supreme Court, and then finally the execution petition. So 10 years, 15 years before you receive your money. And don't worry, during all this period, your interest will keep on accumulating. 1 lakh will become 2 lakhs, 4 lakhs, 8 lakhs, 16 lakhs, and your grandchildren will be very happy. A few judgments. India Glycols Limited, in fact, this is one of the matters which I was handling here in Telangana High Court in this, where it said writ petition is not entertainable for challenging an arbitral award. And this has now been referred to the larger bench, whether this is a valid question or not. So as of now, the law as it stands today, you cannot challenge an award under writ. You can only challenge under section 34. So why has all these things come up? Because of this case called Tamil Nadu Cements Corporation Limited versus MSCFC. Supreme Court in January 2025 referred these few things to the larger bench. Can the same conciliation members sit as arbitral tribunal? And is the writ an absolute bar for challenging arbitral award under section 34? So I'm not going through everything in detail. There's one more judgment which has been referred to the larger bench. Is also there is the 90-day time period. Is it mandated to pass the award? So as of now, some courts have said no, while some courts have said yes. So until this is resolved, again, there is no clarity on the time period. Now you could be saying, why should we be worried about all these things when the new amendment may be let's say, come into force any day? Well, I'm not hopeful that it's going to happen any day soon. Even if it does, all those cases that you have already filed, they're under the existing act, not under the new act. So all those cases, once they are resolved to the MSCFC and they go to court, and by the time you are done with SLP and you go to execution petition, you are still stuck with the existing act, not the amended act. Another important judgment is that Limitation Act is not applicable to conciliation. And that is in fact a standard contractual situation. Your legal remedy is barred by limitation, not your legal right. And that is pretty much what this judgment has said. So just on the side note, a few more provisions. What if there is a specific arbitration clause in your contract? Doesn't matter. It is your choice then. You can choose to go for regular arbitration, or you can choose to come to MSMED arbitration. And third, you can even go to civil court. And if I come there and I don't object, and civil court does not take notice of that, then it is like both the parties have abandoned arbitration and they have chosen civil remedy, the civil court remedy. So this has been clarified by a few judgments, number of them, but I've mentioned 2 of them here. Now, what is important is that you need to be registered before entering into a contract. You need to be registered with the MSMED. It will take hardly 15 minutes and you can log in and get yourself registered. Because if you're not registered, then any contract that you entered into before that you cannot dispute. But is law that clear? What if you have entered into MSME registered today and you have received payment up to today and then you start working from tomorrow on some new or the next phase of that and some disputes arise? Well, that is interesting and maybe you could invoke arbitration for that. And there are some judgments which said yes and some that said no. As I said, see, only buyer cannot initiate MSCFC. Only seller can initiate. This is a very famous judgment, Shilpi Industries, June 2021. But once you enter arbitration, I will draw out my sword and I'll start fighting you. So be very careful. Now, there are several judgments that exclusive jurisdiction is as per the contract, but otherwise as per the location of parties and not necessarily location of the MSCFC. But again, there are some judgments which are the other way around also. As I said, this law is still evolving in the MSMED Act. It is not for works contracts. It's only for supply of goods and services or manufacturing. There are many judgments in this regard. But some said works contract or not, that has to be decided by the MSCFC. And the MSCFC decides that it is not works contract, then courts have, in my observation, have never interfered with that. Courts say it's a hands-off approach. MSCFC is the best suited person to decide that it's a works contract or not. Now, are you a micro enterprise or a small enterprise? That has to be decided by MSCFC also. Now, you could say that you are a medium enterprise today. But if you look at the act closely, it gives away a transition period of 3 years. So there are some gray areas which you could benefit here and there. And for that, it's better to approach MSCFC rather than courts. And calculations or interest, something that cannot be outsourced. It is for the facilitation council to do, or the arbitral tribunal, but not by external party. And this is the same thing everywhere. But for some reason, the facilitation council keeps giving us a hard time and says, we'll let a CA decide that. And we keep fighting with the council. We know that we are winning the case, but we have to fight with the council because I will end up getting a bad arbitral award, which will be thrown out from the courts. And award shall be provided by the arbitrator to the parties, not by the micro industry, small enterprise facilitation council. It doesn't have to be certified by MSCFC, but for some reason they treat it like some kind of a document. They put the seal on it and the stamp and say, here, we are sending you your award. There are some judgments related to that. So always insist that the arbitral tribunal should send to you. An award should be based on merits and evidence. That is mandatory. And there are judgments in this regard. Now, I have prepared 2 small slides with the checklist and experience. First, register on Udayam before signing the contract. Ignore the payment period in your contract if it exceeds 45 days, because by statute, you are entitled to payment within 45 days from the delivery date or 15 days after delivery if the buyer does not raise any written objections. So send the payment demand in writing, otherwise you will not have any evidence. For composite contracts, don't lose hope. If your contract can be separated out for separate the supply and services, you could be entitled for the MSMED. And you can file MSCFC at your registered office. It's not you can, but now you should. And demand 75% deposit before the award can be challenged. Many courts say, why should we challenge that? And they are the tier 2 courts or tier 3 courts where they are not fully familiar with the Arbitration Act. And they say, don't be so hyper-technical. And I'm saying it's not hyper-technical, it's my right. The court cannot deprive me of a right to deposit the money. And remember, you cannot file a writ to challenge the award. And the maximum time period is 3 months plus 30 days. After that, you cannot challenge the arbitral award. But obviously, law is not black and white. There are rules and there are exceptions. And be careful about a few things. If the buyer issues any written comments and does not accept your invoice or your goods or services, immediately provide a written explanation to justify why you should be paid. If there is any defect, rectify it and immediately provide a written confirmation. From then, your 45 days will kick in. So be very careful. Next, I use the term for now. Demand a different person or persons for conciliation, mediation, and arbitration. The reason I say for now is because there is no clarity from the Honorable Supreme Court. Until that is done, I keep on fighting with the MSCFC, saying I don't want the same people as conciliators and mediators and as arbitrators. So you either be a conciliator as of now or you be an arbitrator. You cannot be both. And if you don't do that, I'm going to go to High Court and file a writ and get a direction. So that is my consistent stand as of now. And don't be in a rush to skip conciliation and directly jump into arbitration, which MSCFC keeps on doing because it's a mandatory precondition. Otherwise, your award is a bad award. And prepare correct interest calculations and claim statements because MSCFC is sometimes not spending time going through them in detail. They may rely upon your numbers. So if your numbers are misleading, then your award will become bad. It could be challenged. And ultimately, be prepared for a 10-year battle. And finally, my quotation, the more we learn, the less we know. So with that, I stop here. And I guess we have to open the floor for questions now, right? Before that, may I request Mr. Inba to share any views on my topic?
Sir, Dr. Pradeep, it was excellent. I was very happy that you have narrated in detail about the Arbitration Act applicability and wherever there is vacuum in the MSME arbitration process. And you have rightly spoke about and made the participants to be engaged, getting to know much about arbitration. Thank you.
Okay, thank you. At least that's a blessing.
So thank you, speakers, for the insightful session on the construction arbitration under MSMED Act. So we have a few questions. Our participants have posted in the chat box. So let me read it out. The question is from Sunil Pujari. Sir, is the MSME applicable only to suppliers or it is capable to small contractors too, who's executing works and supply?
I believe I have already answered that in my presentation.
Yes, Dr. Pradeep has highlighted on it.
Okay, sir, thank you. And we have one more question from Vijayashree. Section 18 is totally amended into 2026 Act.
Yes.
He's asked.
Obviously, yes.
Okay. And one more question from Sunil Pujari. Is MSME applicable for all disputes arising in contract other than payment?
Now, as I said, to invoke MSCFC, you need to have delayed payment. That is the key to enter MSCFC. So only if there is a delayed payment, you can invoke MSCFC and enter. Once you enter that, you can invoke all claims and I can invoke all counterclaims. Mr. Inba, do you agree or want to differ on that?
Yes, it all relies on what you highlighted on the definition clause. It's very significant how we are going to interpret the definition one. And as you rightly mentioned out, unfortunately, the Facilitation Council is only for MSEs, not MSMEs. Still this amendment has not taken care of it.
But can we also bring in all disputes?
Yeah.
Like, let's say there is no delayed payment, but if there are other claims, can we still go to MSCFC? That is, I believe, the question.
Yes, sir, that's a question.
I think Mr. Inba, you're not able to hear it?
Not covered. Okay.
I think there's some audio issue.
I think only payment disputes can be addressed under MSMED Act.
Yes, that's what my answer was. I think Mr. Inballs is agreeing to that.
Yeah. And we have few other questions, sir. By Alaka Munde. What is the technical reason behind medium sectors are not covered under MSMED jurisdiction? That's the
Answer is too technical.
Yes.
Okay, let me go to the next question. It's by Sunil Pujari. I found the eligibility requirement for qualifying as micro, small, and medium has increased, which may leave out small business out of the framework.
It is not, because these are all up to. So anybody who is having up to that limit is micro. So there is nobody is left out.
Okay, sir. And we have few other questions by Mr. Anthony. Conciliation Act still relevant now? I mean, after
Yes.
this amendment.
As of now, because this act has not yet kicked in, it is not taking force.
Yes, the Mediation Act is yet to be notified in full. And till that time, the schedule of the Mediation Act won't be applicable. Arbitration Conciliation Act would stand good.
Yes, sir. Our next question is by Mr. Manoj Kumar. Is MSME registration compulsory to refer the
Yes.
matter to MSCFC?
Yes, I've already covered that, and the answer is yes.
The answer is yes. Yes, sir. Thank you. Our next question is by Mr. Alaka. In short, if you can explain, in short, I think the question is not completed. Yeah.
Sir,
Let
I
me go to
think
next question.
Alaka is asking about the medium sector.
Okay.
Why medium sector is not covered?
We cannot answer that.
Okay. Next question is by Anthony. After Mediation Act, under which a conciliation takes place?
As we already
Under
said,
which act a conciliation takes place?
until the Mediation Act is fully enforced, the Conciliation Act will prevail. Then automatically Conciliation Act is subsumed into the Mediation Act.
Mediation Act. Okay. Next question is by Ms. Divya S. Kumar. In construction contracts, where a contractor or subcontractor qualifies as a micro or small enterprises, how does the MSMED Act interact with contractual provisions relating to delayed payments, payment certifications, engineer certifications, retention money, and milestone-based payments?
What is a contractor here? Are you talking about a supplier or a composite work? If it is a composite work for construction work, you are not entitled to MSCFC. If you are only a supplier or a service provider,
I think he's
supplier. Okay, that is the question.
charger.
Supplier, then it is the same thing. You need to provide your bills and evidences. There's been a delayed payment, and the evidence that it has been, your certificates have been received. That's about it. It's a regular dispute then.
Okay, sir. Thank you. And I have a question, sir. Yeah. What is the effect of MSMED statutory interest provisions on a contractual interest clause? Can you share a light on this?
Yes, as per the interest calculations, you get significantly higher amounts through the MSME Act. If you go with Arbitration Act, I'll say the average number somewhere now is around 9 to 10%, or we could even say 8 to 10%. But through
Exactly.
statute, currently you are able to get about 17 to 18% per year, which means that is also compounded. So for that reason, MSMED Act is much better.
Okay, sir. So consider that we have an interest clause in the contract itself. Does the MSMED interest clause overrides this contractual
Yes,
clause?
it's a statutory provision.
Okay,
Statute
sir. Got it.
overrides your contract.
Yeah, thank you, sir. And we have two more questions. By Sunil Pujari. MSME is supposed to be a quick redressal of payment disputes, which you stated 10 years battle in your presentation. It's a practical
That's
scenario.
ground reality. Yes,
Yeah.
within 90 days, but 90 days from when? And what happens if nothing gets done within 90 days? Then let's assume that you get an arbitral award. I'll challenge it under section 34, and then 37, and then SLP. And let's say you complete all that and you get a EP in your hand, decree in your hand, you go to file a EP. How long is that going to take? I can drag you. In fact, that was what happened, I think, on Reliance or somebody. They were imposed a cost of 10 lakhs yesterday by the Honorable Supreme Court for dragging a matter for the last 20 years. So if you have resources, you can keep on dragging for a long time.
Yes, sir. And one more question by Vijay Shri. MSMED Act speaks of conciliation and arbitration, but does not speak about mediation.
Correct. That is the way the Act is now. But once the amendment kicks in, conciliation is gone, mediation will come in.
It's going to be
And one more
interchangeably used in future. Wherever conciliation is going to be mentioned, it has to be changed as mediation once the Mediation Act 2023 is notified in full.
Yes, sir. And the last question by Tyagarajan. If more councils to be formed, means will they empanel mediator and arbitrator?
See, MSCFC does not empanel mediators or arbitrators. They empanel institutions. So you cannot directly go and ask for being empaneled. You need to approach an institute like BEAM and say that we will empanel with BEAM and BEAM kindly take us to MSCFC. So there's no direct route.
As of now,
Yes, sir. Actually,
as of now, many facilitation councils entrust these cases to court-annexed arbitration centers, which are attached to the high courts. And they used to provide these cases to those institutions. And if you are in the panel of those court-annexed arbitration centers, then obviously you will get an opportunity to arbitrate.
yes, sir, definitely. So participants, if you have any other queries, you may send us an email or you may post in the WhatsApp group also. Okay. Before winding up, let me share a short announcement. You know, BEAM, which is consistently strives for awareness and opportunities creation in the second-tier cities. As the managing trustee, I wish to convey the following. BEAM's ultimate objective is to get accredited as the mediation service provider pursuant to the Mediation Act 2023. We invite, the ADR professionals to join hands with BEAM in the mission of affordable ADR in India and overseas. We provide workshops to the law colleges and institutions on MSME arbitration. So whoever is interested, you may reach us through email. We will post the email in the chat box, or you may reach out through the WhatsApp group. Thank you. Over to Stella for the vote of thanks.
Thank you, Madhumitra. Good evening, everyone, and happy Independence Day to each one of you. As we draw this enriching session to a close, it is my privilege to propose the vote of thanks on behalf of BEAM. At the very outset, I extend my heartfelt gratitude to our esteemed speakers, Mr. V. Inbavijayan sir and Dr. Pradeep Reddy, Sarvareddy sir, for so generously sharing their time, knowledge, and expertise with us today. Their insights into arbitration under the MSMED Act and their emphasis on affordable arbitration added great value to today's discussion. We are truly grateful for their invaluable support and guidance to our young team. It has truly been a learning experience for us. Our sincere gratitude also goes to the Builders Association of India for graciously accepting our invitation to this webinar. Their patronage added greater credibility and relevance to today's discussion, and we look forward to their continued patronage in the future. I will also like to thank all the participants who joined us today, despite this being a national holiday and the special occasion of Independence Day. Your presence means a great deal to our young and vibrant team. Finally, my heartfelt thanks to our managing trustees, Mrs. Madhumitra and Mr. Karthikeyan, for their continued mentorship. To all the BEAM trustee members for enabling this webinar, and my warmest thanks to my colleagues and moderators whose behind the scenes coordination made this webinar run smoothly and seamlessly. Before I conclude, I would also like to inform you that the recording of this webinar will be made available on our BEAM YouTube channel for those who wish to revisit the session or view it at a later time. With this, I once again thank each and every one of you for being part of this session. Wishing everyone once again a very happy Independence Day. Thank you and good evening. Jai Hind.
Thank you.
Thank you all. See you all in another section. Thank you.
Thank you.